China, what do we import from India? We import people from India, smart, intellectual people from India. So I was astonished because everyone consider Indian people are potential people. They have good brain. So this workshop is also meant to harness the intellectual property of the Indian people, especially who are in academics. And we are fortunate enough to have Professor Saha with us, who is going to be the external expert. And so I welcome you, sir. And we are having Professor P.K. Sharma, who is Pro Vice Chancellor of our university. I welcome you also, sir. And this workshop is organized by UCRD, University Center for Research and Development. And I welcome Dr. Meenakshi Sharma as well, who is the head of the UCRD, Galgotias University. And I welcome Professor Sansar Singh Chauhan, who is the professor in charge for IPR cell. So let's begin with the that 19th century was a century of oil, and 20th century was the century of manufacturing. Then 21st century is the century of intellectual property. So all the richest person, if you see the list, they are earning money by utilizing their intellectual property rights, right? And one great example is Samsung and Apple case, which comes to my mind eventually. So Apple had some patents over the design and on the Apple phones, and Samsung copied it. And recently in 2014, Samsung had to pay $539 million to the Apple. So if you're holding one patent, if you're selling your innovation, it's good. And if someone else is selling your innovation, it is even better. So you'll be getting money in any way. So with these words, I would like to invite Professor P.K. Sharma, who is Pro Vice Chancellor and Dean of School of Medical Allied Health Sciences. He is having a lot of IPR in his name as well. So Sharma sir. Hello. Sharma sir, good morning. And
good morning.
I would like you to say a few words about our speaker, and so you can introduce him, and then we can start the session. Thank you.
Thank you, Dr. Sandeep. Thanks a lot. Thank you, Dr. Meenakshi. Once again, thank you, in charge, UCRD. Dr. Shah, I welcome you to this very important event, and the university is very much thankful that you have accepted our proposal and spared your valuable time from your busy schedule. My friends, Dr. Shah has been engaged in research, capacity building, teaching and training, policy making, establishing systems, management, and international negotiations concerning intellectual property rights, technology evaluation and assessment, regulatory processes, R&D policies, and project implementation over a span of over 45 years. He graduated from Indian Institute of Technology, Kanpur, and received his master's in engineering from Cranfield University, England. He served the government of India for 35 years in various capacities and positions, including research management. He retired as advisor, Department of Science and Technology. He served as a professor of IPR in Tezpur University. He acted as consultant to many agencies, including Technology Information Forecasting and Assessment Council, Center for Development of Advanced Computing, WIPO, UNESCAP. As a consultant to WIPO, he completed a national study on IPR and MSME in the Indian context in September 2012 as a part of its development agenda. He has been advising many government. He has been advising many government and other agencies, educational institutions on matters related to IPR. He is a senior advisor to Confederation of Indian Industry focusing on IPR since 2011. So friends, I am not finding myself suitable and comfortable to introduce Professor Shah. I had given you a very brief, and on behalf of our university, we welcome you, Professor Shah, to bless us with your blessings so that we may also get a path of IPR. I'm very much thankful to Dr. Meenakshi Sharma also. She has arranged so nicely and very eminently the persons are selected over here. Further, the whole this scenario of the university is changed because of our eminent, dynamic, and very enthusiastic Vice Chancellor, Honorable Professor P.T. Bajaj ma'am. She has been Dr. Sandeep.
Yes, sir.
You can start, ma'am, now.
Yes, sir. Am I audible?
Yes, ma'am.
Shah, sir. Am I audible?
Yes.
Yes, ma'am.
Yes, sir.
Okay, thank you so very much, sir, for your initial remarks. And now I would like to invite the man himself, Professor R. Shah, to enlighten the student with the IPR. The topic name is Intellectual Property Right for Academic Institution. So Dr. Meenakshi, can you share his PowerPoint? So
I'm just sir. Would you share you or I have to share your PPT?
No, please share because I don't know. We should not end up in another glitch.
Okay, sir.
Because
I'm sure.
that screen is my screen is in front of me, so I will not have any difficulty.
Okay, sir. I'm sure.
Sit down. Thank you.
Yes, sir. Screen is visible.
No, it's not.
Now it's visible, sir.
No.
your screen is visible to me, ma'am. So probably sir is having some internet issue. So wait for a few seconds. It may be visible, or you start sharing it again. Start over again.
Sir, now I think screen is visible for everyone.
No, it's
Yes,
not to
sir.
me. So let me see.
Sir, kindly refresh it so that you can see the PPTs.
No, nothing is visible to me, Dr. Meenakshi.
Nothing is visible to you. Now, sir, it's visible?
No, it is not.
Now it's not visible.
No, madam, it's taking a lot of thing from me.
For in your screen that is visible. But the rest of the participants can see in that screen.
Yes, screen share.
So now it's visible?
No, madam.
Sir, we can do one thing. You have to just start. I will next to next according to your slides, because rest of the participants can see in that screen.
Okay, fair enough. So I'll change my slides. Yeah, that I think. Can you hear me?
Yes, sir. Yes, sir. Your voice.
Okay, thank you. Thank you very much. And thank you very much to all Sharmas, Mr. PK, Mr. Sandeep, and Dr. Meenakshi Sharma. And good morning to all of you. Little sorry for the glitches we are having in the connectivity. Anyway, nonetheless, it has been solved. So I'm going to, initially I'm just going to say that intellectual property rights, as was mentioned by Professor Sharma also, is something which is catching attention of everybody, each country and all citizens all over the world. And for students and young faculty, it gives a very good opportunity to really see alternative way of earning money, fame, recognition, etc. If we practice the principles of intellectual property rights. As I go along, I'll be giving some examples to you, and some of the basic things I'll be sharing with you. So you go to slide number 1. Intellectual property, if you see, it has the word property. So many times people feel that intellectual property is something very unusual and is something very complex, and it is not meant for us. But I think all these are conjectures. We really have to first understand the intellectual property. We must understand that any property, when you talk about any property, whether it is movable or immovable, there is a sense of ownership. And sense of ownership basically means that nobody else other than you can use your property without your permission. He or she cannot use the property, cannot sell the property, or do any transaction on that property. So intellectual property also fall in the same category for most of the purposes. We are all familiar with the immovable property like land, house, factory, and immovable property like your car, or it could be a taxi, or it could be a car, or something of that kind. Now, why normally is a very simple question. Why normally we feel so attached to our property? There are many reasons, and the first reason is that you have really spent money on them. You have spent your time, precious time. You preserve it by taking whatever steps which are necessary, and then you have emotional attachment with that. You maintain it. There is an emotional attachment, and then a sense of belongingness. So these are all qualitative aspects of a property, why you feel so attached to your property. Then you take necessary steps to protect your property. Either you will put a fence around your house or around your land, or when you go out, you will lock your house, or in case something goes wrong, you will go to the law. That means you'll go to the police to complain against any theft which has taken place. So the whole system works in that manner. And similarly, all these principles are applicable to intellectual property rights as well. As per the legal position, intellectual property is considered as movable property, and it is not considered immovable property. So most of the principles which are applicable to any movable property in our country, by and large, all those principles will be applicable to the intellectual property also. So can we go to the next, please? Okay, so these are some of the features of intellectual property right. We have got different forms of intellectual property rights, which means like patents, copyrights, etc. And patents are meant for protecting your inventive work, including improvements. So it deals largely with implementation of an idea. So you have an idea and you suggest how this idea can be converted into practical sense. Copyrights are things like literary work, musical work, drama, computer software, films, TV, all these creative work, they fall in the category of copyright, and copyrights deal largely with protection of expression of an idea. So it's important. Neither patent nor copyrights, they protect ideas by itself, but certain features of idea. First one protects how we want to implement an idea, and second one, that is copyright, deals with expression of an idea. Then we have trademark, which are very commonly observed by everybody, like Microsoft, Coca-Cola, State Bank, Tata's, Hamam, all those things. These are the names which go with their product, and they have got also legal protection. Then we have the industrial design. Basically, it means, I'll be explaining all these terms, but just to open the area to more concepts, I'm saying few lines about each right. Industrial design is largely for protecting outside appearance of an article, and it has nothing to do with the functional aspect of any design with which most of the engineers are familiar with. When you design whenever you design something, the functional aspects are always built in. Then we have the geographical indication, like Darjeeling tea. These are names which are associated with some product, which are famous, which come from a specific geographical location. Then we have the layout design of IC circuits, ICs, basically how various electronic components have been put on a wafer. That's what layout design is all about. Then we have protection of undisclosed information, or what called as trade secrets, and then protection of new plant varieties. Having said that, so these are the rights which are available to all of us by law. And what are the nature of intellectual property rights? I'll just go briefly over them. One is, these are all monopoly right, exclusive right given to the owner of the intellectual property. They are all time bound, except trademark and geographical indications, which can be renewed from time to time, but all other rights are time bound. That means after that time period is over, your invention or your intellectual property becomes available to everybody to use. So this is an important concept which really does not hold in case of like for your land or for your mobile. Whenever you talk about IP, we are usually talking about something new and original knowledge, right? We are not talking something which is already known in the knowledge of human domain. So any traditional knowledge, for that matter, like folklore or any medicine, the medicines or any other thing, they are not subject matter of IPR, as we have seen above, except the main A1 right, which is the geographical indication. So all other rights, you are dealing with new and original knowledge. These rights are largely territorial, which means that if you are granted these rights, it will be applicable only in the country which has granted you these rights, except copyrights, which are simultaneously protected under many countries, because India is a member of Berne Convention, which ensures that once a right is created in one of the member countries, it is protected elsewhere as well. So they have to be renewed from time to time, like you pay house tax, for example. They can be gifted, they can be sold, they can be given on rent, like any other property, and the licensing can be done in parts also. It can be held only by legal entities. Generally, what it means is who have the right to sell and purchase property. Those are the people who can have rights, but at the same time, a child is also a legal entity. The only thing under our civil laws is that it is there has to be a guardian for owning that right. As you know, if you want to open a bank account for your child, there has to be a guardian. So there's no restriction on any legal entity. And this is perhaps the only right which can be owned simultaneously in more than one country. Like, you can't have the same house in US and let's say in India, but patent is one right you can enjoy simultaneously in many countries. Same is the case with copyright and other rights as well. So it has got a lot of potential. And if you just exercise your mind a little bit, you'll find that with this property, you can earn so much of revenue because from all over the world, because it is protected in other countries as well. In India, all these rights are awarded by the central government, and these are not the subject matter of the state government. Next, please. Why we are looking at intellectual property now, one is that certainly it became an active subject matter in our country after we became member of WTO. But at the same time, we must realize that the IP laws were there in India since 1856 in one form or the other. IP is very important for trade and business, both national and international. International trade is almost a necessity for all countries, especially for India, because if you really want to generate wealth to feed 1.3 billion mouths, then we have to earn money by exports, because our total, the production in India and the income which gets generated is not adequate to feed all these mouths. So, if the international trade, there's a scope for earning in form of multiple ways that adds to, let's say, our GDP and so on. Global positioning is also required in Committee of Nations. It is important for strategic and defense positioning. And other important and interesting feature is that we are entering Industrial Revolution 4 or it is also called Industry 4.0. Now, Industry 4.0 is something, as many of you would be reading it also, and also you understand that it deals with big data, new technologies, and complex technologies. So it's an important thing, and if we are not ready for take the challenges of the Industry 4.0, I think we will be left behind. And then it is very important from the competition angle, because IP is one of the properties or one of the items or tools which actually keep your competitor away from you. Well, that gives you a better market share. Now, the first industrial revolution, which took place in 1784, when water and steam power were used to mechanize production. This was after James Watt came with the steam engine. Then we had 1870, the second industrial revolution, where we used electric power to create mass production. Third industrial revolution, which is placed around 1969, used electronics and IT to automate production. And now we are in Industry 4.0. And please remember that India was nowhere either in first industrial revolution, second industrial revolution, or the third industrial revolution. In the fourth industrial revolution, yes, we have got certain strength, but we are still not completely ready to become an active player of Industry 4.0. And I personally believe that if you don't have a good stock, good portfolio of intellectual property rights, it would be difficult to compete in Industry 4.0. And that is where it is considered essential that our academic institutions, universities, they become competent in these aspects and also train the new human resources who would be fit to take these challenges. So These are the reasons, in my opinion, these are the basic reasons why we think that IER is intellectual property is important. Now, often, we try to put our research into two components. One, we always say basic research, and we also talk about either applied research. I like to call it as innovation-driven research in the modern context. Basic research, we don't see any application in the near future. Few of the outcomes of basic research, they cannot be protected under the law as defined by the law. It will lead to technical papers and books, which is copyrightable item, know-how, database, protocols, and possibility of patent is very low as far as the basic research is concerned. Innovation-driven research, they're application-driven, legally protectable, like patents, through patents, designs, copyrights, technical papers, and also databases, protocols, and at the same time, basic research and innovation-driven research, they can coexist because one, basic research is usually a precursor of the innovation-driven research. Innovation and IPR, we often use the term innovation and invention a little loosely. Invention is basically meant to solve a solution to a problem which the human beings face. But an invention by itself is not a product. To convert invention into a product, many steps are involved. And I'll explain to you as we go along. So innovation is much more than invention. And I would urge all of you to see that these terms are used properly, because unless we use these terms in the right context, we tend to make mistakes in our day-to-day pursuing of our specialty as well. So legal protection is, I mentioned it again, is through intellectual property. In earlier days, even if you look at the definitions of given by many organizations like World Bank, or for that matter, OECD, and or that matter, American government, innovation means is something in terms of new product or new process which can be disseminated in the market. Invention by itself, you cannot disseminate because it is not in the form of a product. It is even if you make a product, it may be just one piece, but going to the market, you need things in large number. There's a lot of optimization is required by the time you want to go to the market. So innovation is for innovation, any innovation, IP is something which should be taken as a necessary precursor, because I see many startups in our country who start ventures without paying any attention to the protection of their intellectual property. And what we find is after 2 or 3 years, many of these startups pack up because there is no venture funds available to them, either under Series A or Series B, because the venture capitalists don't see that product as a likely successful product in the market, because there's no IP protection, because IP protection is the biggest tool to keep your competitors at bay. So it's an important thing. So I believe there are many students who are also participating in this workshop. The message is for them, and also for the faculty who should actually build in this concept at different stages when you are taking classes. Now, if you look at the economic significance of IP, they can be used, IPRs can be used for raising funds using IP, and IPR as collateral. Like when you go to the bank, you mortgage your land to take some loan or something else. Similarly, there is now quite an emerging trend where patents and trademark and copyrights are being used as collaterals to seek funds from banks and other financial institutions. If you want to attract investment in your countries, or investment in general, and in particular foreign investment, IP play a very important role. Then it contributes to GDP in a big way, or it can increase your GDP. For competition, as I mentioned, it is a very important tool, especially if you want to avoid competition, either in short term or medium term. Wealth generation, I've already spoken, improve exports, and it helps generate employment. Now, I'll just share two slides with you. One is the study by OECD, which has come out with a very interesting results. It says 1% increase in trademark protection increases FDI by 3.8%. 1% improvement in patent protection increases FDI by 2.8%. And 1% improvement in copyright protection increases FDI by 6.8%. You know, what are the copyright industry in our country? Film industry, the music industry, any industry, the publishing industry, they are the major ones. Now, of course, the broadcasting also is a major industry in our country. So if this protection and improvement in protection is 1%, it can bring in or raise FDI by almost like 7%. So this results, Indian data is not part of this study, but yes, these are important things. There are new evidence in the sense earlier we never realized the influence of IPR into FDI. Now this is another study which was done by, it has been done by WIPO, which says the average contribution of a copyright industry to GDP is about 5.5%, which is quite large. And contribution to national employment is 5.3%. Now you imagine, you know, if the IP industry or IPR have got such large potential of contributing to the national economy, then why not practice it? And why not practice it in a very, very dynamic manner? Look at the academic institutions, how IP are important. So I've listed few things. For example, if you want to improve quality of research, you have to play a very active game in IPR. Unless your patent portfolio or IP portfolio is good, it is not very likely that people will consider quality of your research in your institution in a very respectful manner. If you are engaged in IPR, your research speed has to go up. And this is a part of Industry 4.0, that any research which is carried out, it has to be extremely fast. Because unless it is fast, unless it comes to the market quickly, you have an issue because there will be a lot of competitors. And that is why now in the literature and otherwise also we use a term like complex technologies, which mean a product is full of many patents, and these patent holders are from different countries, different industries, and large number. For example, your smartphone, which you usually use, it has got something like 250,000 claims, or on average, I would think about 8 to 10,000 patents. That 8 to 10,000 patents cover a smartphone which you are using every day, and 10,000 patents would mean something like about 200,000 inventions or maybe more. So that is the reality, and that complexity has to be understood, because those days are gone where you make very simple thing because which don't meet a large number of aspirations of the people or the user. That product is not going to last long, and it will not be very competitive. So research, and as such, research has become very competitive. I could see from your description of your university that you are doing a lot of research, a lot of PhD students are there. So you have to understand that research is also competitive. Earlier days, there were few countries who were engaged in research. There were only technical papers which used to come to you through magazines and other, and that is the source of deciding which topic to research on. But today, the situation is so very different in the sense that a lot of literature, everything is available today, and the research is being conducted not in 10 countries, but maybe in about 50 to 60 countries. They're very active. So research itself is competitive. So if you want to make an impression in research, then you have to realize this fact. If you want to have research collaboration from other universities or industry, again, IP is going to play a very important role. And I can tell you, even in US, even today, when a large industry, especially like, if you take COVID-19, so I read about many industries who are going back to universities for creating something new, which can find quicker solution to the problems which we are facing. If you want to remain up to date in your knowledge, I think IP is one of the most conducive and most progressive factor. If you want to attract funds for research and infrastructure, including funds from government, even if your university wants to obtain fund from the government for, let's say, building up infrastructure or some other thing, or maybe new things will come up, then IP scoring is going to play an important role. And same is the case if you are trying to get sponsorship from industries or some other agencies. Slowly and slowly, people are going to pay attention to the ownership of IP rights by your university. Developing employable human resources is something which is the need of the day. And in fact, I do see that curriculum in universities are changing, but I really don't know whether they're changing so fast to make the students directly employable in the company the moment they pass out. So, what will happen with passage of time? The industries are going to change their complexion, and hence the requirement. Hello, can you hear me?
Yes, sir. Yes, sir.
Yes, so
We are at slide number 16, sir. Sorry for the disconnection.
okay. So let me go back to 16 because that means I was speaking to myself. Okay. So I was talking about significance of IPR and academic institutions. If you have a good IP culture, then you will be able to develop employable human resources, which is the need of the new industry, because they want people who are trained in some of the new things. For example, large data handling. And if a university is as good as the faculty it has and the students, PhD students and BTech students you have. So it's important for attracting faculty and students. If you want to enhance your image and reputation globally among peer universities and institutions, IP portfolios play a very important role. And if you have time, whosoever has time, you can look at the IP portfolio of universities like MIT or Caltech or Purdue and all these places. If you have good IP, for example, because your research will be accordingly very focused and meaningful, then you have a better chance of getting them published in reputed journals. It's important for supporting technology incubation and startups. Your faculty can write good books if you are sort of in with the modern knowledge which is happening. Because it's a kind of a legal, the whole patent thing, another IPR is a techno-legal thing, and where you'd have to generate a lot of documentation. So you learn to, can you go to the next slide, please? Yeah, so you learn to document research because you have to maintain lab records, test results, etc. You learn how to protect and maintain IPR. You can generate funds through licensing. You can strengthen academic ethics like eliminating plagiarism. Culture of maintaining confidentiality is important whenever you are in collaborative research or when you are sponsored by an industry to carry out some research. Confidentiality is a very important thing. Standard setting, I mentioned that standards have become extremely important in all the complex technology product like smartphone and laptops and even driverless car and all those cases. And these standards are developed by industry. And these are not developed usually by government agency because you're talking about very fast changing technology. And today the trend is, especially if you look at machine learning, IoT, etc., the patents come first, and around those patents, then you try to develop the standard. So the standard is the starting point for a product which you want to sell in the market. So if your research is actually related to standards, for example, then it gives you a better chance of joining these discussions when the standards are being framed. And then is the regulatory framework. All of you know that if you want to put a drug into market, suppose you have researched and you have found out a drug, it has to first undergo animal trials, then phase 1, phase 2, phase 3 trials before the drugs can be put in the market. Similarly, even in the engineering areas, the standards have become so important that if you really want your invention to be converted into a product which meets certain standards, then the knowledge of standards and also how you invent around the standards have become important. Next, please. So these are changing facets. I've given the title. Knowledge generation and accumulation is happening at a very, very fast rate. Something like 1 exabyte of information digital information gets generated every year. Now, this was a data maybe about 10 years back. Today, maybe it is more than 1 exabyte, which is 10 to the power 18 bytes. Now, when you start doing research, you have to look at very large pieces of information to decide which topic to work on. The societies and nations need to respond fast to convert knowledge to their advantage. That in a short response time. This is one of the important feature of Industry 4.0. If you are not fast enough, then you may as well assume that you are nowhere in the race. So if you want to be in a race, you have to run fast. Anyways, it's a very simple message. And the definition of how you run fast also keep changing with time. So today you may say that, okay, I want to put my invention into market in 5 months time or 7 months time or 1 month time. So choice is yours. So if your prior work is complete in the sense is exhaustive work you have done, extensive work you have done, then the chances of getting into launching your product in 2 months' time or 3 months' time after development is possible. Globalization is another aspect. And so it comes from the competitiveness thing and also from the export point of view. Because, earlier days, there used to be a barrier on exports. You cannot go and sell your product in all the markets very freely. Same was the situation. You could not import a lot of things. But today, as the boundaries, nations are becoming seamless as far as the boundary is concerned, the scope of selling your things in many countries is very high. And if you capture a large market, your income will also increase, perhaps exponentially, because in exports you definitely get, you can charge more price for the same thing as compared to what you charge in the domestic market. And all these things give us an idea that it is becoming complex. And even if you look at WTO agreement in general, apart from the TRIPS, there are many chapters which actually have to be combined along with IP to have a successful foothold in the global market in your area of work. Now, can you go to the next slide, please? So some of the things I've already spoken, but I would like to draw your attention to bullet number 4, which says concurrent development of new technologies and legal paradigms. Now, law is playing a very important role today. Even whenever we are talking about utilization of a technology, because public interest is already involved. So what we say is, for example, patent, which is a good thing, to define new technology. It's a technical matter, scientific matter, but you cannot get a patent unless you meet the legal requirements in the law. So it's a techno-legal kind of a situation which we are facing today. And in case of any disputes, okay, in a society, disputes will always emerge. Disputes will always remain of one kind or the other. And for dispute resolution, normally you go to the court. Now, the moment court come into picture, the law, the technology, how you sell it, how you market it, how you process it, everything becomes important. So it's a techno-legal requirement, techno-legal framework, or techno-legal aspects of intellectual property rights, which are important. The other point is about taxation. See, whenever you do any technology transfer, you have to pay certain taxes, income tax, for example, or maybe GST, because if it's defined as service to the government. Now, the reason why I am bringing in this factor of taxation, the globalization, the technology, the changing facets, data size, other thing, the whole idea is that we have to understand these things. And what I'm saying is not necessary that we can't get patents on any other aspect of technology. That's very much there. But in order to meet the challenges, then of course the standards and plagiarism we have already talked. So these are some of the important new facets. Next, please. Like AI and machine learning, Internet of Things, 3D, biopharmaceuticals, standards and patents. These are all important aspects, important things which we are going to witness in the coming days. They are going to change at some point even the legal paradigm. So we don't know, but it's important. And you know that India is going in a big way of doing big data, and there's a lot of TV advertisement today with advising the students to learn coding, and universities are buying NVIDIA and other GPU systems. So there is a thrust in this area, and that is why all these things become very important. For exports, it's very important, which Indian industries still don't realize. What it really means is that if you want to export your product in a different country, and usually these products will be covered by either trademark or by patents or sometimes by copyright. Unless you have protected them properly and legally in that country, anybody can copy your trademark. Anybody can use your patents for making things in that country, and you don't get any benefit out of it. So it's a loss. You cannot be a good export player. But sometimes people can use this trademark in a negative manner. One example is of the punni rice. It's a rice which is grown in Tamil Nadu. This is exported in a large quantity to Malaysia because a large Tamilian population there, and this rice became very popular. And it was sold as punni rice. And some trader in Malaysia took a trademark called punni, same spelling. And then he started sending legal notices to this trader saying that you cannot import this rice and sell it because I have the trademark. So it became a really complex issue. But finally, I understand that it was sorted out at the governmental level. So of course, now the punni rice is being exported. But the point is, if you're not able to win this battle, then you lose a big chunk of their market. As I said, it adds to better chances of selling and marketing, because even all the time you don't go there to sell your thing. You will appoint some agent, appoint some some other party to sell it on your behalf, and in that case, contracts are also involved. Now we come to specific IP rights. These were the general thing, I think, many times to give you an intellectual reasoning, intellectual rationality. You need some broad parameters for your understanding, but let's come to specific IP rights. So we come to patents first. As I mentioned, patents are given to you for inventing something new, product or process. Okay, and when you say it gives you this thing, there are certain constraints on that. I'll come to that. A patent is valid for 20 years from the date of filing your application. Okay, so normally what happens is if you have an invention, you will describe your invention in certain manner, and then you will apply to the patent office for award of a patent. So that is why the date of filing becomes important. It is 20 years from date of filing. Next, please. So some images. This is an image of cream separator, the patent for which was taken by Alpha Level in 1878. Next, please. Matchboxes. Even you can get a patent for the matchbox, and you'll say, why? How come the matchbox we have been using for years? Yes, but imagine boys, if you take active part in kitchen with your mother, or ladies who use matchboxes, you know that what happens in monsoon, it will not light. So if you are able to develop a matchbox where the side where you rub the thing and the stick, they don't get moist in monsoon, then it would be a major breakthrough in matchboxes. Next, please. Next. Next, please. No, you have to go back. Okay, next, fine. Next, please. Yeah. No, I think there's. You have gone through ahead. Let me see. Okay, we are at this slide. This is a patent of a transistor junction, which was applied by Schottky in 1956. So how simple it looks. If you go a little backward, please. Can you go a little backward? Yeah, and this is this. One more, backward, one more. Yes. Now this is an image of fork which you use in your day-to-day eating. Why I picked this slide? So the first patent on fork was somewhere in 1800 something, and there have been developments on that. Fork have been designed in many different ways, but initial days the patent on fork was not given because the government said, or the clergy people said that if you start using fork for eating, how will you use your fingers? So even such reasoning was there at one point of time. Of course, it's not there. So I thought it will just break the monotony. Next, please. Next, please. Yeah, so pharmaceutical drugs, they're candidate for patent. Next, please. Next, please.
Yes, I'm trying, sir. The computer is.
Yes.
Visible now, sir?
Yes, it's all fine. So this is the invention of Thomas Edison on the first incandescent bulb, which was taken in 1880. Next, please. Next, please.
Is it moving, sir?
No, it's not. I can't see it because you are moving it. So I can't see it. It's not moved. It'll go to the next slide, which is of transistors. Yes. So this I have already explained. Next, please. So now the law defines new invention. It says what a new invention means, which basically means that it should be globally novel, it should be inventive, and it should have some utility. Next, please. Now, the law says that all inventions can be patented. This is a general understanding, but as per the Indian laws, there are certain exclusions. That means certain inventions, they are not patentable in India. Now, like for example, any frivolous invention, say for example, you say that I have designed a perpetual motion machine, those kind of claim or frivolous inventions are not patentable. And invention whose primary use or commercial exploitation would be contrary to public order or morality, then it would not be patentable. For example, anything which you develop is prejudice to human, animal, plant life, or health or environment. That means if you have something which causes environmental pollution and causes prejudice to human beings or animals, that is not patentable. Mere discovery of a scientific principle, like for example, Raman effect or theory of relativity, they are not patentable. And similarly, if you discover something from whether it is living or non-living, then that discovery is also not patentable. So, for example, if you discover a microorganism from soil, which is occurring there, it is not patentable, even if you are the first one to discover it. Next, please. So the mere discovery of a new property of a known substance is not patentable. For example, there is a substance which is already known, and you just think that its melting point is not known. And if you find the melting point of that substance, then your invention is not patentable, in the sense that you will not get patent for that matter. You will only get patent for the process by which you have actually worked out or you have determined the melting point of that substance. And it's very specifically in the Indian context, and people who are in chemical engineering or chemistry or biology, biotech, they will understand it better. Salts, esters, isomers, polymorphs, metabolites, pure form, particle size, a mixture of isomers, and their complex combinations, they are not patentable in India unless you are able to prove that they differ significantly in properties with regard to efficacy of that substance. Okay. Now, this is a very unique law in India, because this is not true. This is not followed in many other countries. And this is a point which you please remember, that each country may have different laws as far as patenting requirements are concerned, but there will be different in very, very minor issues, but broadly they are the same. Next, please. So if you have an admixture of many things, then admixture if it shows new properties, then it is patentable. For example, take example cement. Cement is a mixture of ferric oxide, gypsum, and so many other things. But the moment you put water and when it solidifies, it is no longer in the form of a powder. So it's totally a new effect. Okay. Similarly, take detergent, for example. But that means if you put A plus B, it should lead to A plus B plus some delta or some epsilon. Unless if this epsilon is 0, then you cannot get a patent on any admixture. Similarly, mere arrangement or rearrangement or things in a product which function independently is not patentable. For example, you take an umbrella and put a bulb all around it, and the idea is that if you are walking in rain, then somebody coming from the other side will immediately realize that somebody is there. Now, if you have a switch in your hand to switch on the bulb and you open the umbrella separately, then it is a rearrangement because the umbrella and the bulbs, they are acting independently. They are not linked together. Then, so it becomes a case of rearrangement. And there are many cases where, and famous cases where people thought they have done excellent research in automobile, but courts found that that was basically a rearrangement on known things. And as a result, their patents were nullified. So it's an important thing, especially for people who are especially mechanical or electrical discipline, but can be applicable to any other area of knowledge. A method of agriculture or horticulture that is not patentable in India, for example, terrace farming. If you do terrace farming, that will not be granted any patent, or similar things. Terrace farming is just one example. If you have any process for medical, surgical, curative, or prophylactic, that means preventive, diagnostic, and therapeutic, and other treatment of human beings, that treatment per se is not patentable. For example, you may have a special way of doing a surgery, or a special way of giving a medical dosages, then those things are not really patentable in our country. Next, please. Inventions related to atomic energy, they are not patentable, especially if you're talking about fissionable material. Then mathematical or business methods or a computer program per se or algorithms, they are not patentable in India. This gives a lot of worry to many people, but what is behind it is that if you write, let's say, simple program to solve quadratic equation, and without any practical application of that, then that will not be patentable. But if you have a software which solves certain thing and which helps in final application, for example, it may increase the memory of your system. It can do the calculation faster. If calculations are done faster, for example, if you take IoT kind of a thing or 3D kind of a thing, then it can have a faster results. Then certainly software along with this kind of hardware can be patented. But on its own, an algorithm by itself will not be patentable in India unless you are able to link these things. And this is a major challenge when you're dealing with the applications for things like artificial intelligence. Plants and animals in whole or any part thereof means the plant, if you say I have generated this plant, no, or if you generated new plants, no, no patents can be given for that. Or if you are able to develop a human part, like for example, a hand, artificial hand, not the mechanical hand, but actually the artificial hand, that is all will not be patentable except the microorganisms which are having some human intervention. That means if you are changing the microorganism through biotechnological means or genetic engineers, so that genetically engineered microorganism will be patentable in India. Presentation of information, like for example, web design, it's not a subject matter of a patent, but it's a subject matter of copyright, which will come to it. And topography of integrated circuits, again, there is a separate law how to protect the topography of integrated circuits. A mere scheme or rule or methods of performing mental act or method of playing game. For example, if you bring out a new game in cards it will not be patentable in India, but maybe in US. And any invention which is a traditional knowledge or which is derived from traditional knowledge, that will not be patentable in India. When I say derived, means direct derivation, but there may be certain things like, all of you know, turmeric is used for wound healing, and there was a big fight which India undertook in 97 or something like that. So turmeric in its form, like if you take turmeric powder, mix it in milk and drink it, then it helps, removing the infection or quick healing. Now, this cannot be patentable because it was already known in India for a long, many years. But if you develop a tablet or a capsule or an injectable turmeric, then that injectable form can be patented. The capsule form can be patented. So you have to see in the context of your laws in your own country and how you can sort of go around that laws and protect your invention. So when you apply for a patent, I mentioned that you will see whether patent is novel or not, inventive or not, whether it has the utility. There are certain exclusions in law, which I have already explained, and whether you have described your invention in detail for practicing or for implementing. These are the essential features. So first is novelty. The invention should not have been published anywhere in the world or practiced anywhere in the world. So the direction is you have to file for your patent as soon as possible. If you don't, then someone else is going to file the patent and take the advantage of that. The second thing is that your invention should be inventive. Now, for obvious reason, you will always think that what I have done is definitely inventive because I have put a lot of hard work. But what happens in the legal context is your invention should not be obvious to a person who is skilled in the same art, right? So, suppose you are a PhD student and, you go to your guide and guide says, oh, I have read something with similar to that. That means, you go back and check your invention, whether it's inventive or not. But if we say, wow, that means there is something. So basically what I'm trying to say is that it should not be obvious. So, which means that it should not be a mere extension of, let's say, textbook knowledge or mere extension of what has been published in some technical literature or what has been produced somewhere. So it always becomes a little critical thing to see whether your invention is inventive or not. So I've given an example of a stool. So normally whenever you go to a doctor place, he'll ask you to sit on a stool, which is usually the steel metallic stool, which will have 3 legs. And we know that, that principle of physics also, Lemma's theorem, that when 3 forces meet at a point, that point would be in equilibrium. So minimum number of legs which you require is 3. Now if somebody comes along and says that, look, I have got 4 legs and it gives me more stability, that will be a mere extension. That will not be considered an inventive step. Similarly, like in a cupboard, you have the wooden knobs, you replace the wooden knobs by metallic knobs. That will not be considered as inventive enough. And the other thing is that your patent has to be useful. So in your patent document, you have to really say how it is going to be utilized, either in terms of a process or in terms of a product. And you have to give the scheme of things as well. Now, here are some examples. For example, if I give you a thin wire and ask you to stitch cloth with it, you will not be able to do it. But the moment you make a hole on the top, then it becomes a sewing needle, right? And sewing needle invention was patented at some point of time. Similarly, you have a case for gem clip. So you bend the wire in a particular form, then it becomes a gem clip to hold papers. And similarly, they were all patented at some point of time, right? You look at Coca-Cola can, there is a clip at the Coca-Cola can to open it. And one gentleman had a patent for this particular clip. And when Coke and Pepsi and other people came to know about it, they thought that it was a very useful application because it was very easy to fill bottles with spurious so-called Coca-Cola and sell it in the market. So there was a lot of, I wouldn't say plagiarism, but something. Can you go to the next, please? I'm sorry, I forgot. So this I was explaining. So I'm sorry, I'll have to go back because I thought I was changing my slide. So it's happening there. This I said that, since but the point is basically as you should be able to file your patent application as soon as possible, number one, and your invention should be globally new. Because if you don't, the conclusion is that if you don't file your application fast, someone else is going to, file for the same invention, and then you will, lose your right. In UK, somebody filed an application for doggy's bell, which meant that a dog can press a switch, kind of a palm switch, and somebody from inside can open the door. The whole idea was that in winters, you have to take the dog out for attending the nature's call, and then you have to be around with him and then come back. So you lose time. So the whole idea was that, you can let the dog out, and when he is free, he'll come and press the bell, and you open the door and then let the dog in. Wonderful invention and wonderful thought, but this person lost the patent because same idea has appeared as a cartoon few months back in some newspaper or magazine. So what I'm trying to say is that time is also an essence. Next, please. And then we see this invention, we call it inventiveness. What inventiveness means, you must have heard about it on the stool example, although the picture was not there. So I was talking about three-legged stool against five-legged stool or two-legged stool, which will determine the inventiveness. Next, please. Then you have to really show in your patent application whether your invention, what is the utility of that invention, which is an important aspect of any patent document. Next, please. So I was talking about sewing needle, and I said that if a thin wire, if you make a hole, you can stitch cloth with that. But if there's no hole, then you cannot stitch. So simple inventions of this kind, and these were patented earlier also. Similarly, gem clip and ball pen. I was talking about Coca-Cola can. So there is a clip, and I was saying that it really provides anti-duplication device. And this person who had the patent, he licensed this patent on this clip to Coca-Cola and Pepsi and, companies of that kind. And he said that every can which you sell, you will give me a royalty of 1 cent. And I believe his daily income was few crores or few hundred of crores. Those figures are not there, but he earned a lot of money on this basic particular invention. And still, you remember that patent is out, but this clip is still being used. Next, please. Next. So so inventiveness is there. I've explained to you technical advancement. I'm spending a little longer on inventiveness because this is becoming a new tool for examining whether an invention should be given a patent or not. If you have not understood the stool example, then from chemistry, we know whenever we react sodium hydroxide with, let's say, HCl, you will get sodium chloride and water. If you look at the periodic table, the same principles should be applied to potassium hydroxide also. But for a moment, you assume that potassium chloride was not known in the art. And here is one chemist who says that, look, I have found a way of making potassium chloride by using potassium hydroxide and HCl. So a patent examiner is likely to say, well, your product is new, but your process is not inventive. So process, you will not give a patent. So this is how it works. Next, please. So next, please. Yeah, so I'll give you some examples. This is about carbon dioxide laser. Now, carbon dioxide laser is used for cutting metals and very fine machine operations. Carbon dioxide laser is red in color. And whenever you use laser, you also use an aiming beam to identify the exact spot where you would like to perform the operation. Now, the point is that earlier days, people were using principle of refraction for focusing the beam on the spot. And you know, the best way of focusing the beam is using a convex lens. But the problem was the material which were used to make convex lens were either glass or something like that, and which were allowing all the wavelengths to pass. So you imagine, you know, there is a laser which is red in color, aiming laser red in color, and your actual laser, the operating laser, is also red in color. So it's so difficult to identify the spot. Imagine a situation of a surgeon who is operating upon human liver, everything is red. So this was a problem in the art. So somebody came along and said that, okay, what do we do? So he said, we also read something like reflection in our school days. Can I use the principal reflection? The answer was yes. Next, please. Yes. So the answer was yes. So, you know, they've written a guidance element. Now, this is a reflective surface which can be used for reflecting the aiming beam. And earlier days, aiming beam used to be red color. Now, because of the reflection, it can be in different colors, blue, green. And so you are able to identify the spot very easily. So this was a good invention. Next, please. Here's the example of pacemaker. Okay, pacemaker. So most of you know that it really used to regulate the pace at which your heart beats. So you will have a sensor which picks up the heartbeat, voltage, and signal, the well-known ECG signal, and then try to work on it. Now, ECG signal has got both low frequency and high frequency components. Next, please. Yes. And then at that time, you will use two operational amplifiers to handle low frequency and high frequency signals. And as a result, the problem was that it generates more heat. The size of the pacemaker was larger. It consumes more electricity, and the batteries run out fast, right? Now, you'll not like to have pacemaker where battery runs out every 6 months. Now, of course, today the situation is very different. Next, please. So somebody said, smart guy says, we also studied the friend biquadratic circuit. Can we use that? And the answer was yes. So they reduced from two op amplifiers to one operational amplifiers and solved the problems partly. So, you know, you can see there is a problem, and you have to identify the problem or problem and then see what solution you are providing. And their solutions have to be different, and they have to take care of the problems which you have identified. Next, please. Next. Okay. So here we have got, it's not only the talk about circuits and other things, even in your dresses, you know, there is a possibility of getting patents. So this was a patent which was allowed to, you know, leave people for, you know, they worked out a cutting pattern in such a way that if you make a trouser, it will give you 20% saving in the cloth. Now, 20% saving in the cloth is quite huge, and you know, which will be in many different ways. So they'll change the cutting style or something else, and that means that they're dependent very largely on the ergonomic data of men. Maybe this is for Levi's brothers, maybe for men in US, but a good thought had gone into it, a good problem identification there, and the solution was also made available. So it could be for shirts. Now, here is an example of for chemical engineers and chemistry people. You know, this invention deals with the azadirachtin, which is a compound found in neem tree, neem seeds, which are which are kind of act as pesticide. But the traditional method in which we extract azadirachtin is something that, well, you put it in water for overnight or something like that. But the shelf life of azadirachtin was very low. And here is a famous company. They identified this problem. They said that the shelf life is very low because it degenerates in UV radiation, and the pH itself changes and the shelf life goes down. So they thought about the solution and they defined their problem in the following manner, that they will develop a storage stable azadirachtin formulation which retains 80% efficiency or efficacy after 1 year storage at room temperature. Look, the manner in which the problem has been defined. pH should be between 3.8 to 4.2, and you will use some kind of a solvent, in this case, aprotic solvent, to achieve this goal. Now, this became a major patent in India also. There was a big controversy on this particular patent because this came somewhere in 90s, and we were all up in arms, and they say, why, what is this that these people have taken this patent? And, and there was a parliament question also. So at that time, we actually studied this patent, okay? And I did it myself. So we said, oh, well, there is nothing, nobody has taken away your azadirachtin because it is only a process to improve its shelf life. Now, this is the kind of education, understanding of the subject is required. In our late 90s and early 2000s, there were a lot of fights of this kind. There was a fight on neem, and there was a fight on turmeric, and so on. Now, we come next, please. Now we come to the other right, which is called the industrial design. And basically, this is the right. I'll show you some picture. Again, the concept is that your design should be new and original. That's the important thing. Second thing, all engineers who are sitting here must realize that industrial design does not deal with the functional aspect. Okay, so it deals with outside appearance of an article, of a three-dimensional article. That is very important. The duration of protection for industrial design in our country is 15 years. Patent, it was 20 years from date of filing. And in this case, it happens in 2 steps. First, you get protection for 10 years, then you have to ask for another 5 years. Next, please.
Sorry to interrupt, sir. We are running out of time a little bit. So,
I started at 11:15.
Yes.
So you have to tell me how it is to be done.
So, sir, we can move a bit faster if you can. I mean, it's up to you.
So by what time would you like? Tell me the upper limit of my time.
15 minutes more we can have.
15 minutes more.
Unfortunately, 30 minutes?
Yeah, 30 minutes would be reasonable. So,
okay, sir.
Can you go to the
Sorry
next
to interrupt, sir.
Can you go to the next slide, please? Next slide. Yeah, so you see this different bottles for mineral water. They look different. They look very differently in shape, size, everything. So they're a good candidate for industrial design. Next, please. Coffee mugs, for example, there is an ornamentation over the coffee mug, white dots. So they give you a better understanding of the design. Next, please. Coffee mug. You have these various tabs which are candidate for industrial. Look at their outer shape and design. Don't go into the functional aspect. Next, please. These are the textile designs which can be again protected under industrial design. Next, please. Different type of apparels, they are part of industrial design. Next, please. The outer shape of this mobike, for example, not the functional, how much fuel it consumes, no, but otherwise you have to really look at it. So this is also, in fact, the nano problem, IP problem was related mostly to the industrial design issue. Next, please. So it could be socks. Next, please. It could be different apparels, as I mentioned. Next, please. Could be jewelry. Next, please. And so on. So that's what now we go to trademark. And trademarks actually are the name given to a product. It could be a distinctive sign. It could be a combination of words. It could be a number. It could be letters, drawings, and combination of various things. So this is by using these things, you try to define your product, which stays in the memory of the customer. The term of protection for trademark is 10 years from date of filing, but it can be renewed before 10 years have expired. Next, please. So these are various things which you see in your day-to-day life. Next, please. This is a famous trademark, Tom and Jerry. And you see this trademark has become so popular and known still, and still is maintained. The function of trademark is identifies the source. Different trademarks distinguishes a product, helps in advertising, creates brand loyalty for mergers, franchising. Yes, when you actually try to define a trademark for yourself, it should have the following qualities. It should be distinctive. Name could be stylized, that means you write in a certain manner. It could be signature. It could be fanciful, invented word like Caltech or for petrol. It is better to have words which are not in the dictionary. Now here you see two packets of namkeen. They look so similar. One is by Kaleva and one by Haldiram. Although little colors are different, but suppose you block Kaleva and Haldiram, you would think that both the products are from the same producer. And this is how trademarks are duplicated. They make certain changes, but if they go to the court, then court is certainly considered as a trademark infringement or violation. Next, please. So otherwise, these are the things. Your trademark should be easy to recognize, easy to remember, easy to pronounce, easy to spell. Next, please. As I said, if it's an invented word, then it is always a good trademark. For example, Xerox, for example, Pepsi, for example, Coca-Cola, and so on. But at the same time, next, please. Next. Yes. So, this is an interesting thing that sometimes your trademark becomes generic. That means people start using it as a general term. For example, you always say, make a Xerox of this paper. Okay, we normally use this term, but Xerox is a trade name of that company which has actually designed this machine. So in order to avoid, because if the producer of the machine don't take enough care, then this trademark will become generic, and then you can be using it for any other purpose, and the value of the trademark will be vanished. So what Xerox people did, they did a lot of public campaigns and other things, and making sure that Xerox is used in the right context. You don't say Xerox, make a Xerox of this particular paper. So like this, all these names which you see here, nylon, kerosene, escalator, which you use in all the malls now, they were all trademarked earlier, but they became generic. So, people have started using escalator for any device which can take you up and down. Next, please. So if you have good trademarks, this is the brand value of various trademarks which are there in the market. And they certainly are important component of advertising. Things and secrets we have to know, we have to actually ascertain that it is not shared with anyone else. Okay, this is point number one. And if it is to be shared, it is to be shared with well-defined, let's say, people in well-defined manner, so that it remains a secret. Now, all other rights which I have shown earlier, you have to apply to the government. Okay, then giving all the whatever information is asked. Trade secret is one right, for which you don't have to apply to any agency, because the moment you apply to any agency, it becomes known to everyone. So it is a self-regulated right, but It's very important, which is used by many companies as a matter of practice. Some people even say that 50% of your market value is, or the technology is assumed in trade secrets. So it's an important right. Next, please. So next, please. So you can see, the formula can be trade secret. You don't disclose your chemical formulation. For example, all of you or people must have seen the movie. What was it? Mugambo Khushua. Okay. So that bracelet was actually a trade secret. Similarly, there have been many cases. So it could be a formula, it could be compilation, it could be your software program. It could be how you cost your product and what is the source of raw material and so on and so forth. Well, yes, one thing is there, trade secret is something which should not be known to everybody. But at the same time, if somebody comes up with the same thing, that you cannot take that person to the court because that person has done it independently. But that usually does not happen. So normally what will happen is somebody from the company would take away the trade secret when he goes for a new employment. And that is one way. And you have to prove in the court of law that such and such event has taken place. And you should be able to place your finger on the person who has stolen the trade secret. It's becoming a big issue today. Next, please. So these are various things. You can extend this. Next, please. So one way of safeguarding trade secret is then you convert your secret in tangible forms. Let's say even a text or a table or graph. Put it in CD drive or whatever it is, and you have to convert information into a tangible form, because in case of dispute you have to show it. Then you have to maintain the records properly. You can mark confidential, secret. You have to identify who are the people who are authorized to see this information, etc. So there are a number of ways in which the trade secrets are maintained by companies. Next, please. Okay, here is a case which happened very recently. Some employee from Google, he left Google, and it was a project dealing with robotic vehicle. After leaving Google, the gentleman was Anthony. He set up a company, OTTO, OTTO, working on self-driven trucks. And OTTO was bought by Uber. Now, Google has sued Uber for a violation of its trade secret, which were taken by Anthony when he was in Google. Uber, without any case, paid $245 million to Google because they could not afford to go to the court and then say, okay, what are the trade secrets and etc. So the out-of-court settlement was there. But Anthony, as a person, he is facing charges of trade secret violation on 30 accounts, 30 different reasons. And he faces, what is the kind of punishment? This is a US case. What kind of punishment he is facing? 10 years of imprisonment and fine up to $250,000 on each count. That means 30 accounts, and each count means the total will be something like about $7.6 million. So, this kind of damages are not awarded in India. That is true. But the point is today, because the turnover of employees, people leaving one company, joining others, and then, you realize only after 5 years or 6 years after the employee has left. So it is a major problem. And this is something which has to be sort of, developed right in the beginning. And all those people who will be going for employment, you may be required to sign this kind of bonds where you will be required to say that you will not read, will not share trade secret or confidential information with anyone else. And this is something very important. And unless you sign those documents, you will not be able to join such companies. Next, please. Then we have the protection of integrated circuit layout design. Is basically on a wafer chip, how do you arrange your electronic component? That is what let's call it layout design. it is not the IC per se. IC means, that means electronic circuit design is not there, but it is the organization of various components on the chip. So this is a chip. Inside it, there will be a lot of transistors and capacitors and resistors and whatnot, operational amplifier. They're all converted into some kind of a chip design, and they go along with that. There's a law for this in the country, but we have not received a single application so far. And the term of protection for layout design is 10 years from date of filing. So this is right now is of a theoretical value, because we have not seen such things. And in fact, in US, they don't follow this law. They don't have any law of this kind. They directly go for a chip design and protect it through patents, largely patents, and sometimes copyrights as well. Next, please. Next. Okay. Now, then we have the geographical indication. I mentioned in the beginning, geographical indications, basically, they're the names which identify a good. The good can be agricultural good, natural goods, manufactured good. These goods originate from some geographical locations, and they have a reputation built over many years. Okay, so such goods can be protected through GI registration. What it really means is that nobody can use that name for a similar product which has been produced in some other part of the world. Next, please. So these are some geographical indications I've said, but today the list goes into 300, 360 or so, and the Indian thing is there. So let's say Chanderi sari, it is weaved in some village in Madhya Pradesh, and they are sold as Chanderi sari. Now, for example, you take somebody makes similar sari in Surat. The question is whether that person can call it Chanderi sari or not. As per the law, he is not allowed. This used to happen earlier, but no longer, because now there is a registration of GI. But this is basically what it means. Similarly, Kulu shawl, it's the same story. That if these shawls are woven in Ludhiana, can it be called Kulu shawl? As per the law, no, but still the practice goes on. But these are the rights for which we did not have any law in the earlier days before the WTO came. But now there is a law. So this gives an idea about how to protect your traditional knowledge also. Next, please. The GI is protectable for a period of 10 years, but it can be renewed from time to time. If you violate the GI, there could be an imprisonment of 2 years or a fine of up to 2 lakhs of rupees. Then we have the legislation on new plant variety. What really means new plant variety is if you are able to make a plant variety which is different from the earlier plants, then you can get a registration for new plant variety. So it's also a form of IPR. So for example, everybody knows red rose and other things, but people have not seen red rose dotted with white dots. So if somebody is able to come out with a plant rose variety with white dots on it, then it would be a new plant variety. So similarly, like any other form of IP, it has also got a next, please. Next. Yeah, so it has got a protection for 15 years. If it is a trees or vines, it will be 18 years. So basically trying to say that there are very definite legal provisions. Next, please. Next. Okay. So copyrights, I've already given you an idea what it covers: literary work, software, engineering drawings. Let's go to the next, please. So as I mentioned, copyrights give protection for expression of an idea, not the idea itself. Please remember that. So if 5 people make a painting of rising sun, they all have their own copyright on it, provided they have not copied from each other. So it's important that expression has to be original. So these next, please. These are something, this is the artistic work. Next, please. Artistic work, somebody has made this thing out of flowers. Next, please. Architecture work. Books. Next, please. These are the engineering drawings, which most of the engineering institutions don't realize, but all these engineering drawings which you make, next please, they are protectable under law. They can be protected as copyright. So it's very important for engineering students to know. Next, please. This is painting. Next, please. Dance form. But in dance form, it has to be sort of captured on some kind of a video so that you can always say that this performance was done by XYZ individual. Now, copyrights. Let's go to this. The concept came from the copyright product came from the West when after the advent of printing machine. Next, please. Next, please. Next. Okay. So copyright registration is not essential. So if you, let's say you write some piece, some textual, some essay, you can put your signature. If you put your date, that itself should be good enough for protection. But what happens is in case of dispute, there may be many arguments which may be placed saying that, oh, this is not there, that is not there. As you know, that arguments come in many different ways. But in India, we certainly advise that you should have a registration for your copyright work because that is a proof. You see what happens in copyright violation, you can take the SHO of a police station to the premises where the copyright violated works are being stored or it's being done. So just a little catch. Next, please. So as I said, copyright is not applicable to ideas, facts, procedures, concept, principles. No, it is only how you express an idea. So, you can write a novel about an idea, you can write a poem about an idea, you can draw a painting, you can create music, whatever. Now, these are the rights which are available to the copyright holder. That person has the right, is the only person who has the right to reproduce the work in any form, issues copy of the work, perform work in the public. For example, from a novel, you make a play and then perform in the public or communicate it to the public. You write papers, they get published in various journals. So once they are published, it's a communication to the public. So you make films that will be our sound recording, they're part of copyright work. You make translation of a work, okay, from let's say a book in Hindi, you translate into Malayalam. Now, the right to translate is with you. And if somebody says that I'm going to translate your book in Malayalam, that person has to take permission from me. Okay, so that will be, you have to write a contract and then you can always give that translation right to that person, make any adaptation of the work, converting it to poem, etc. Next, please. So in case of artistic work, there are two interesting features. The rest of the rights are same. Two interesting feature is there that if there is a three-dimensional object, okay, or a two-dimensional object, and you want to depict that in 3 dimensions, that would be a violation. That is only right with you. But if somebody does without a permission, that would be a violation. So suppose you have drawings of a certain things, and from wherever you have got, and you convert into a 3-dimensional object, that would be a violation of the copyright. Original work in 2 dimensions. Similarly, if a 3-dimensional object is there and you want to convert into 2-dimension thing, it is without permission, it would be a violation. So a lot of animation work and cartoon work, cartoon films, it is basically, it's in 2 dimensions, right? And you have various characters. So if you pick up a toy, for example, which you like as a character, you convert into 2-dimensional work, that would be a violation of the copyright of the person who has actually made the toy. So it's very important, very, very important, because this is a good way of protecting your right, especially when you are in the business of animation or similar things. Rest of the things are okay. Next, please. Next. The only good thing about copyright is that if you use a copyrighted work what's called a fair use. For example, you use a book chapter from a book for teaching purposes or report writing or some term paper, then it is not considered as a copyright violation, but very, very limited use. Rest of the things are there, but we'll skip. Term of the copyright is author's life plus 60 years. Suppose I write a book today. So my right will be there till I die, and 60 years after that also, that right will be with me. And obviously that right will pass on to my heirs. So this is a very long lasting right, which is available. Work for hire, suppose as an employee, you prepare a copyrighted work, then the ownership of that copyright, ownership of the copyright will go to the employer. So this is something which you must understand. Even this may be applicable to your university. Okay. Then there's authorship right, and this is where the plagiarism come. Plagiarism basically means that you take somebody else's work and project it as the work created by you. So you have done copyright violation, plus you have also taken the authorship right. Let me make a simple, Gitanjali is a book written by Rabindranath Tagore. Suppose I reproduce with Gitanjali and say authored by R. Saha. This would be the violation of authorship right of Rabindranath Tagore, and which is a violation which can be treated as cheating and you can be punished. Although in copyright law, punishment is not prescribed. So, plagiarism, it leads to many unethical practices in the universities, colleges, and other places also, and which is a misuse of funds which are given to them for creating something original. And plagiarism has become such a complicated thing today that UGC has come out with guideline on plagiarism. And also international publication, they have become very particular on this issue. Now, this is something, let me wind up in another 2 minutes. This is about basically, we have to understand that patent by itself does not define a single product. One product will have a number of patents. A single patent product is very, very rare. But as I explained, that if you want to, I gave you the example of glucometer, unless the regulatory aspect is satisfied, you are nowhere. Similarly about the standards, we have already talked about it. Now, these are the things, my experience is, but I have been looking at, next please. Next please. So standards, I have already told you. Next please. So, what we have found in many research proposals which I assess, I find many researchers are not sort of very conversant with these concepts. People will say, I'm going to develop a medical device, but if I develop something, nobody buys it. The reason is that you have not looked at the regulatory aspect, how you are going to take them. Many startups are also having a similar problem. So it's as I mentioned earlier, it's a legal framework, legal interface whenever you're talking about IPR. Next, please. So just incentive part, each university can have its own incentive schemes for professors, students, staff. Next, please. And these are various things which can be written. This is for publicly funded institutions, but similar policies can be developed by even a private university like yours. So, how do you decide what allocation of extra funds for infrastructure or something? Obviously, a department which has got few patents and you have been able to transfer them, then they are entitled to higher incentives. And at the university level, it is very important to carry out some kind of audit of your intellectual outcomes, because after all, when you file patent application, you do spend a lot of money into it. And the other things, these are the do's and don'ts. Don't publish your work, present before press, give lectures. If you plan to file a patent application, don't share your work with anyone without a no disclosure agreement. Do not destroy your lab records, maintain them systematically. It's an important thing. File applications a patent application as soon as possible. Follow the progress of patent application closely because this is in your interest. Pay all fees and submit responses to the patent office in time. Pay maintenance fees if interested in keeping the patent alive. But this is for patent, but there's similar kind of things you have to evolve for trademark and design, whatever precaution you have taken. So I just want to say that your patent application, the drafting of patent application is very important. What patent application or specification will contain is discussion on the prior art. That means what was there before you invented something, how you are addressing the problems faced in the prior art. You describe your invention. If you're in chemistry thing, you have to give equations and tables. If you're an engineer, you have to give drawings. Mechanical engineer, you have to do drawings, but not necessarily engineering drawing. They don't require any dimensions and other things. If it is a software thing, you have to describe it through various block diagrams and so on and so forth. Next, please. Next, please. Thank you. So sorry that it didn't work initially, and sorry that I had to rush. Thank you very much.
Thank you, sir. And first and foremost, a big thank you to Professor Arsa for such an enlightening and informative session. And I especially like the concept of contribution of IPR into the national GDP and the cases you discussed in this talk, like the NEEM case, and you have covered every IPR aspect in detail. And I'm sure the students and faculty member would be definitely benefited out of that. And I must mention my deep sense of appreciation to you, sir, for that. Apart from that, I would like to express my sincere thanks to Vice Chancellor of the University and Pro Vice Chancellor, Professor P.K. Sharma, for his initial remark. I also wish to express my gratitude to Galgotias University Center for Research and Development, and IPR Cell for enormous cooperation and support throughout from the organization, from the planning and organization, and for providing the logistics. And we are extremely sorry for the initial glitch, and I'm sorry to you, sir, as well, that we faced some initial technical glitch out of this. And in the last but not the least, the most important people, the participants, I'm sure they must have got a real sense of IPR, and we would like to implement your suggestions and ideas towards the faculty development and student development, and will like to include these insights into our courses through IPR Cell. Thank you, sir. Thank you all participants. And I'm sorry again for the technical glitch. Thank you.
Thank you very much, everybody.
Thank you, sir. Have a nice day, sir.
Same to you. Thank you very much.